So I wanted to, I'm really excited that Judge Firestone is here. And I'll let him introduce himself. And he, as he said before, he's been teaching this subject for more than 50 years. I found a quote by you, Judge Firestone, that I found inspiring, and I thought I would just bring it as a way of introducing you here. You were quoted in an article by saying that you like to tell your students that your objective is simple. You want them to be able to pick up a New York Times and fully grasp what's in there and ultimately develop a more sophisticated understanding of politics. We are a diverse group here of different people from different places and different cities. And I'm excited and honored and grateful that you're here to give us your wisdom. You'll speak for a little while, and then we'll open it up for a discussion together as a group. Judge Firestone, please take it away.
Okay. In fact, it's not just the New York Times. I said that for American students because that's the most sophisticated daily newspaper they're likely to encounter here. So it's a pretty broad group of things they could pick up and learn from. I just want people to develop a more sophisticated, nuanced understanding of the subject. I'd start by telling you that my parents lived in Austria, and when my father's family lived in Pittsburgh, they had emigrated to this country in the early 1920s. So it was a place where they could go, but my parents were not yet married, and my mother did not have those kind of connections. So they were forced to flee illegally into Belgium. The Belgians were quite hospitable to refugees, and that hospitality lasted until the Nazis attacked in May of 1940, and then they were forced to flee south into France. And the French had constructed concentration camps in the at the foot of the Pyrenees for refugees from the Spanish Civil War who had fled Spain when Franco won. And the Jews who fled south were put into these camps, which is where I was born. So I have a strong appreciation for democracy, a strong appreciation for the consequences of evil government and war. And it's something that has been with me all the time. Parents were very interested in it, and I was interested. I remember hearing the news when I was a 6 and 7-year-old boy about the creation of Israel. I remember names that to most Americans would not mean anything, like Ernest Bevin, for instance. Those of you who you see, our English friend knows what I'm talking about, a very important labor leader who was strongly anti-Zionist in the Attlee government. And these are things that were second nature to me. So I come by my interests very honestly, and my respect for democracy very honestly. Incidentally, I know how much Israelis appreciate democracy. It may be, however, that is it 4 or 5 elections over 2 years is perhaps a trifle too much democracy. And in that sense, your system probably could use improvement. Now, I'm not suggesting the system that elected Donald Trump is the one to emulate, but there are things in regard to stability here that have been helpful. Well, let's talk a little bit about some basic American values as they pertain to law. And I have no objection to anybody going beyond legal questions into general American politics. We begin with the most basic principle. American politicians like to carry these pocket constitutions around with them and reach in a coat pocket just to show, aha, what I'm doing conforms to the Constitution. What you're doing doesn't, as if one has more authority than the other to make that statement. In this, there's also the Declaration of Independence at the end. The Declaration doesn't have constitutional significance in itself. Of course, these are the words written by Thomas Jefferson and first heard on July 2nd, 1776, and then articulated on July 4th, our Independence Day. And in their Jefferson rights, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, and then let me underline this verbally, deriving their just powers from the consent of the governed. Aside from the fact that this is a breathtaking hypocrisy from Thomas Jefferson, who was a slave owner, a brilliant man, and a great president, nonetheless, these words, hypocritical as they might be coming from Jefferson, uh, set the tone for what one of the abiding principles of American public life has been, that equality at least is an aspiration to be achieved, if not something that is in practice. And indeed, since the beginning of the 20th century, certainly since the end of the First World War, the struggle for equality has been a very, very important part of our political and constitutional history. And Jefferson wrote these words, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. Ladies and gentlemen, that is the core articulation of what democracy is about, that government's powers depend upon accountability. I always give my students the example. How many of you have ever had a parent tell you you can't do something, and you pester your parent enough? Why can't I go to this party? Why can't I do this? Why can't I do that? And they say, and finally you say, why? And your mother or father will have said, because I said so. Everybody has said so. I know that my wife and I have both said that to our kids, and this is precisely what democracy is not. Because while we're accountable in terms of the belief we have that we're doing what we're doing for the best interests of our children, we are the last word. In a democracy, government cannot be the last word. It must be accountable to people through certain procedures, election procedures, separation of powers as we have in our country, or vote of confidence one has in a parliamentary system is in your country. But that accountability is at the very core. So everything we talk about here has to take into account the fact that government has to be accountable. Now, sometimes government is too accountable. And this accountability in the American political system comes from two structural features. First, the separation of powers, and second, federalism. Separation of powers is unfamiliar to those of you in Israel and from England, from Manchester, for instance, because there we have a fusion of power between the executive and legislative branches. The executive is the leader of the legislative branch, and the executive certainly has to be accountable to his party or the coalition that has selected him. But to that point, he governs. In our country, it's different. In the United States, the separation of powers means there is a constant tension between the executive branch and the Congress, a built-in tension. It's desirable if you don't like what the executive does. It is less desirable if you feel there are challenges and jobs that need to be done. Effective presidents have often been viewed as dictators by their opponents. What was said about Abraham Lincoln when he was president is virtually unrepeatable. What was said about Franklin D. Roosevelt, who was one of our three greatest presidents, Washington and Lincoln being the other two, in the years of the Depression, who took charge of government and literally functioned as a democratic dictator. And yet the challenge was such that it was acceptable that he do that sort of thing. There were plenty of constitutional questions about what he was doing. For instance, the day Roosevelt became president, was inaugurated in March of 1933. He was the last president to be inaugurated in March. Then it became January. The banks were in such trouble that there was no guarantee that your money would survive what is called a run on the bank. People would go to the bank when a rumor occurred about the bank being folding, and people would lose everything, all their life savings as a consequence of that. So Roosevelt declared what was called a bank holiday. The banks would be shut down for a certain period of time. Did he have the constitutional authority? It is not clear at all. In fact, I would suggest that there is no place in which you could find authority for that. His opponents said this is an act of dictatorship. It probably was. Yet it was an important part of shoring up the economy at that time of emergency. So when we think about questions like this, about accountability, and about one of our basic values being that of limited government, sometimes we accept the fact that government has to be more powerful. In our political system, over the last year and a half, we've seen an example of a national government being unable to field a coherent response to the COVID-19 challenge. Now, part of it is the president himself. I hope that nobody here will be upset if I tell you that I think that Trump is probably the worst president in the history of our country, utterly incompetent. But and one cannot say that about Netanyahu. You have your issues with him. This was a very, very smart person who was very knowledgeable about what he was doing. Well, Trump, let's say, was president for 4 years. We'll leave it at that. And his inability or lack of desire to do anything about this was crucial. You had 50 states with different sets of rules about what people could do, about whether or not businesses should be shut down, whether or not schools should be shut down. And in the midst of all of this was the argument that was made regularly, this is a free country. You can't tell us what to do here. The questions about wearing masks. Just today, I think, I read that a poor storekeeper was killed because the individual asked somebody to wear a mask. I mean, it's just insanity, and the kind of negative inspiration that was brought to this using basic American values certainly is something to which the president has some fault, I think. One of the ways in which we pursue accountability for government is something that is quite unique to the Israeli system, to the American system. And that wasn't a Freudian slip. And that is what is what is called judicial review. If any of you know anything about American constitutional law, Rabbi, you might recall this from college. The famous case goes back to 1803 called Marbury versus Madison. The case of Marbury versus Madison is one in which the Chief Justice, our third Chief Justice, but a great figure in American political and legal life, was John Marshall. If any of you has ever gone to the Supreme Court, you'll see a huge granite statue of Marshall on the ground floor, black granite statue, wonderful. And in it, Marshall was confronted with a request to overturn what President Jefferson was unwilling to do. These three men who had been appointed magistrates and for whom Jefferson was unwilling to take the final step of delivering their commission had sued in the Supreme Court. And Marshall knew that if he were to order Jefferson to do it, Jefferson would simply not comply. And Marshall had no authority to order an army to compel Jefferson to comply. It was kind of like the question the Stalin had raised about the Pope. How many divisions does the Pope have? Well, John Marshall had no divisions. On the other hand, he wanted to maintain the dignity of the court. So he argued, he stated in the opinion that his reading of the law suggested that the law under which these men had sued was in contradiction to the Constitution. And therefore, that law could not provide them any relief. In other words, using it, the reason lawyers like it so much is it's a great lawyer's trick, using an interpretation of the law to suggest that the court could not do what essentially was right. He said these men probably deserve their commission. And since that time, the court has taken upon itself the right to overturn actions, first of Congress then of the states, and then of the executive branch, if those are deemed to be unconstitutional. They weren't used that much through the 19th century, but they were certainly used in the 20th century. And they became the subject of tremendous contention. In fact, one of the early great battles between a president and Congress took place in 1937. Well, from 1933 to 1937, a very conservative Supreme Court determined that several pieces of New Deal legislation, laws that Roosevelt felt were essential to the economic revival, were unconstitutional, had to be struck down. This resulted in Roosevelt making the biggest mistake of his presidency in regard to domestic politics, when, because of the huge size of the victory he had gained in 1936, biggest landslide in American history, other than George Washington, who did not have any opposition. Roosevelt said that he was going to try to enlarge the Supreme Court up to 15 members. You see, in our system, Supreme Court is established by the Constitution. It serves for life. That is established in the Constitution. Its members serve for life. But the number of persons in the court is set by law. So that's something that could be changed by law. And since the later years in the 19th century, the number has been 9. And now Roosevelt argued that, in fact, perhaps the number should go up to 15 if necessary. And clearly all of the new people added to the court would be liberals. In a sense, he had Mr. Fink. I saw you're the Manchester guy, right? He used the example of the British government in the early years of the 20th century, when the Tories would be unwilling to pass a progressive domestic legislation, when the king was prevailed upon finally to say that he would enlarge the House of Lords to the point where the House would be made irrelevant. And I think Roosevelt used this idea in part, at least. And so what happened was that there was such a reluctance to make the court appear to be a creature of the presidency that Roosevelt was forced to withdraw the plan. But the court, in any case, changed its ways during the administration, and it remained much more pliable for administration policy until the 1990s. So the idea that the court needs to be separate was given some kind of quasi-sacred status, in fact. This is an issue that is being raised right now because the Republican minority leader, well, now he's minority leader, he was majority leader then, McConnell, chose to not have a vote on a successor to a deceased Supreme Court justice, which would have brought Merrick Garland to the bench when he was nominated. He did it, he said for a year he wouldn't do this. And when the surprise of Trump's election took place in November, clearly that meant a seat of the loss to the Democrats. And conversely, when Justice Ginsburg died only a short time before the presidential election last year, he called for a very quick vote to affirm a successor, and he did. He got it, and that has caused such a significant imbalance in the court. So, if we take together some of these issues, the fact that the government is supposed to be limited, the fact that the court has tremendous power. Right now, the power of the court is thoroughly in the hands of conservatives, whatever that. And in fact, McConnell said recently that if he were confronted with another Democratic appointment, he would not vote on it. Then we've got a pretty difficult situation. Another there are the other fundamental principles of our political process relate to the liberties that people have, what's called civil liberties. And that is the rights that we find in the Bill of Rights. You know, the Bill of Rights was ratified 4 years after the body of the Constitution in 1787. This is 1791. But the opponents of the Constitution made it clear that if there were no Bill of Rights, which were essentially there to protect the states, then there would be no ratification of the Constitution. So an agreement was made that the Bill of Rights would be added, and the Bill of Rights adds 10 amendments, which one might actually view as part of the body of the Constitution itself. And here we have a lot of controversy, a lot of issues. For instance, the First Amendment, which is at the core of what we think of as civil liberties: freedom of speech, freedom of assembly, freedom of petition government, freedom of religion. All these are very, very significant. And they are the subject, they have been the subject and will continue to be the subject of litigation. Let's take, for instance, religion. When I grew up, we went to elementary school in the 1940s and into the 1950s. And I didn't graduate high school until 1959 during the presidency of Eisenhower. This is the way every day began. The teacher would take a Bible that was on his or her desk. The Bible had been provided by the state of Pennsylvania. It was bought by the state. And state law mandated that the teacher would read certain passages from the Bible. We all sat there, we pretended to pay attention. And at the end of it all, we were told to say the Lord's Prayer. I didn't know that the Lord's Prayer was not a sectarian prayer. It was a Christian prayer. And some people would mumble something, say something else. I still know it. But we were mandated to do a Christian prayer in school. And then we would stand up and pledge allegiance to the flag. Those first two practices were found to be unconstitutional in 1981 and 1982, when parents brought lawsuits. And believe me, the amount of controversy that was raised by these attacks on school prayer, as conservatives argued, an unwillingness to accept God in school. Indeed, it was the Lubavitcher Rebbe, Schneerson, the father-in-law of the successor, one of the great figures in Hasidic thought, who said that America would be in great trouble, but it was turning away from God. But of course, the mainstream view this as not just acceptable, but as long overdue. Today, it's not so much an issue, except that it was the progenitor of the arguments that the court was unconstitutional, behaving unconstitutionally against American values. Questions of speech go back to the First World War, right after the First World War, when at least 2 or 3 of the cases involved Jews themselves, not as Jews so much as radicals, who were found guilty of violating certain laws which prohibited saying things in opposition to the government during wartime, during World War I. The first of the cases, Schenck versus United States, contained with it the great statement by Justice Oliver Wendell Holmes, one of the most important judges in American history, who said that freedom of speech gives one the right to say everything, but does not give one the right to shout falsely fire in a crowded theater. And it was this analogy that was, in a sense, it was an articulation of a protection of speech, but it also came to be used as an excuse to prohibit speech in many cases. And in our country, especially during the horrible years of McCarthyism, from the late 1940s through the 1950s, when speech was suppressed on the grounds that it was a mandate to undercut American liberty and American freedoms. So speech was the Constitution discovered, I should say the judges discovered, with their great power, that there was a right known as privacy. Now, all of us would accept the fact that privacy is important when we think of privacy as the right to be let alone by government. Government should not be intrusive into our lives. I think everybody accepts that. There was no such word, but the most important and controversial time that argument was used was in a case called Roe versus Wade. I'm sure all of you have heard of that. Roe is the case that held that state laws which limited the right to abortion were a limitation on the right to privacy. And if you take first the cases regarding freedom of religion, the not free exercise so much as the establishment of law cases, Congress shall make no law respecting the establishment of religion, with school prayer being seen as one of the elements of establishment. And now we come to those who were 1961 and 62. We come to Roe versus Wade, 1973, and the successor cases, and we see the creation of a whole body of jurisprudence which finds illegitimate the civil libertarian move of the court. And from 1975 on, 76 on, the question of whether a prospective judge is pro-life or pro-choice, pro-life being a nice way of saying anti-choice, whether a judge is pledged to that kind of thing. That has been an essential part of American life. Take somebody like Trump, for instance. I don't think it's any secret to say that this man had, among other sterling qualities, a rather liberal sex life in and out of marriage. And yet Trump made his alliances with pro-life forces, the one would think of as being primarily religious, because he saw this as an important part of his political base. It is really a poisonous part of the way Americans think about the Constitution and about privacy. But it has become really very, very important. And every judge that is being considered is always asked how you feel about Roe and others, and they will all say very correctly, it's not appropriate for me to talk about cases that could be before the court, but everybody seems to know where they're going to be. And that's why we continue to be very, very divided. There's another area in the First Amendment and beyond that, which has been very important, and that is equality. Although I use the word equality to talk about, as it was used in the Declaration of Independence, the fact is equality doesn't really appear in the Constitution. The words equality don't enter the Constitution until the 14th Amendment, after the Civil War. And after the Southern states were governed, at least during a period of which Southern states were governed by military governors and had no choice but to ratify the 14th Amendment, which called for equal protection of law. And first time, equal really becomes important. Well, we know that the issues of equality and the jurisprudence that the court has developed regarding equality, from 1954 on, especially Brown versus Board of Education, even before that, and Brown is one of the great cases in history of the Supreme Court. Equality has become a very, very significant element in American law. And American law has generally protected minorities. It has generally extended equality, although there's reason to be concerned in few years, but not 1900, say, in 2013, the Supreme Court, in a case called Shelby County, Alabama versus Holder. Eric Holder was the Attorney General of the United States in the Obama administration. The state of Alabama, this county in Alabama, sought relief from the supervision of the federal courts over what it could and could not do in regard to voting, access to voting, and so on, because voting, the various voting laws had provided for protection for minorities. And writing for a bare majority, well, today the majority would be much larger because of the change in the composition of the court. But Chief Justice Roberts held that time had passed and it was no longer necessary for Congress to have this review function. And that has been viewed as a prelude to a very serious, very, very serious attack on equality and on voting, which is maybe the last of these issues that I can bring to you. The question of whether or not the attack on voting, let's put it this way. I'll try to speak in a neutral way, that just coincidentally, states that are governed by Republican legislators and have got Republican governors have passed into law and have seen enacted laws that restrict the ability of persons to vote, either by mail or by in different groups or over different periods of time. The last election saw a huge expansion of the vote to people who formerly were, in many cases, unable to vote just because of the circumstance of their employment, for instance, or the fact that the polls were closed early. And now all this changed, and there is an attempt, very clearly concerted, to limit voting again. What happens here is an important constitutional question. I noticed, I told you I would talk for 5 or 10 minutes. I think as most of my students have would tell me I've gone beyond that. But let me give you a few points to think about at the end, a few questions that become important. First, free speech and assembly. Along with Oliver Wendell Holmes, the most important advocate of speech was Justice Louis Brandeis. Brandeis and Holmes were known as great dissenters. He came from the most aristocratic of Boston families. Justice Brandeis came from a German Jewish background who came to the United States to be merchants in the middle of the 19th century. You might know that Justice Brandeis was the leader of the Zionist movement in America from 1914 to 1921. And you might want to compare that to what the leadership of the Zionist movement in America is today, which seems to be an offshoot of Netanyahu. Brandeis was a person of great distinction and authority. He also was a great believer in free speech. And these are famous words attributed to Brandeis. The best antidote to bad speech is more speech and free speech. Now, I caution you, Brandeis wrote those words before Joseph Goebbels was in practice in Germany, and before anybody could have imagined a group like QAnon, which offers these huge lies, which are believed by so many millions of people. And so one of the things we have to ask ourselves is, are there dangers to too much speech? I mean, I don't have an answer to that question. I would never presume to suggest that I know what speech is best. I do know what speech is bad. And it raises a subject that came up before QAnon, that of hate speech. Supreme Court has held. In fact, Justice Scalia, one of the conservative justices, nonetheless, was very strong in advocating the government governments could not pass laws restricting what we think of as hate speech, demeaning others. But think about this. Not only does this speech hurt others, be very, very painful to those who are the objects of it. We all know, I think everybody here is probably aware of what happened in Skokie, Illinois, when a group of Nazis wanted to march through a community of Holocaust survivors, saying Hitler didn't kill enough. There are people who say that all the time. Mr. Fink, you mentioned earlier in Manchester, in England, how pervasive anti-Semitism is. Well, it's becoming that way in this country too. And aside from the pain that survivors would feel, this really carries with it the danger of bringing more supporters. You know, I can't even begin to think of how crazy QAnon is. And yet there are millions and millions of people who believe it, who believe that Hillary Clinton was conspiring with the owners of a pizza shop in Washington, D.C., to engage in pedophilia. I mean, these are demented ideas. And giving them freedom is, I suppose, something that is part of the cost of this, Justice Brandeis would say, but it's very, very difficult. Second question. We all know why government should not be all powerful. We all know the fear of totalitarianism and so on. But on the other hand, is the value of positive government doing good things so great, is to allow government to become abusive of the rights of those who disagree with us, but who try to stand in the way of government. And I'm thinking especially regard those who question whether or not government should have the power to compel mask wearing or the power to do other things that most of us feel it ought to have had the power. I think it's something to think about. The question of judicial review. Upon review, should the government have found that the right to get an abortion was a fundamental right? Well, I believe it is, and I think most people I know believe it is. And yet this coming from the courts rather than coming from elections gives the opportunity to individuals who are opposed to it to say that this is essentially undemocratic and an example of judicial dictatorship. And it's an interesting question. Question of equality. This is the area of the greatest success of our courts, but as you know, equality is not just limited to racial equality or religious equality. It is now broadened, and I believe correctly so, to questions of gender equality, sexual equality, what we call LBQ, and so on. And that, again, creates issues that are not altogether acceptable by many Americans. And finally, how do our courts and our political system protect voting rights, protect the right of all Americans to have the ballot? Well, these are things that I have thought about for a long time. I apologize for touching them in such a brief way. I couldn't do anything else, but I wanted to make you aware that they're important matters in American constitutional law. And if any of you have anything to say or any questions to ask or any disagreements, please feel free to do so. But that's the longest I've talked since November.
So before we go and we take a question, and Jenny, I see you there. We'll stick around a little bit extra time. I know I have a meeting that I have to get to soon, so I know I have to leave pretty soon. But I wanted to first of all just thank you, Judge Firestone, for honestly a fascinating, however long that was. I was certainly riveted. I think I could listen to you all day long. So grateful for your time and your energy. I
can assure you, you won't have to worry about that.
Well, I would have enjoyed it nonetheless. I want to just take a moment before we go, Jenny, for you to do your follow-up, and just very briefly hand it over to Elisheva, who is going to talk a little bit about what next week is going to look like. Elisheva, will you just take a moment and share what the subject of next week?
Sure. I was asked if I would do a review of what the status is of civil rights laws that pertain to LGBTQ community. As I have started to kind of look into it, there is an enormous amount of material. A lot of it is historical, a lot of it is of less immediate, what's the way to put it? It's certainly relevant, but it's not of immediate concern because it isn't a problem at this point. So what I'm planning to do is kind of a quick review of those things and maybe choose a couple of things that are actively being fought and dealt with at this time. So I certainly don't have the level of expertise of Judge Firestone, and I have to say that constitutional law, while I was never a specialist in history or law or anything like that, did work for the New York Civil Liberties Union for a number of years. It's always been a topic that fascinates me, and it did my heart good to hear you talk about these cases that are so important
Thank you.
to things that we hold dear. So thank you. And that's kind of what I have in mind for next week. And we still have to decide on a date.
Rabbi, if you get in touch with Debbie, I have several copies of I always give these to my students. Would you like one of these? I'll have them sent out. If you'd like your own personal constitution, I'll be happy to have one.
I'm grateful to say, Judge, that I have mine handy as well. So thank you.
Rabbi, if Debbie gives you, I'll have Debbie give a couple of these to the shul, and you can have them sent out to the participants.
Wonderful. Thank you very much. We have to come to an end, so I want to give Jenny the last word because you were very respectful with your hand up and everything. And I'll just say that I believe you can check your. We'll send out an email sometime between now and next week. But as right now we're scheduled for 2 p.m. on the 23rd next week. That's Pittsburgh time, and that's 9 p.m. The 23rd Israeli time. But check out in your email if there are any updates there. Jenny, since we have to go, I'm going to give you the last word to share your thought there.
Oh, well, my thought was more of a question for Mr. Firestone. I have this concern about differentiating slander from free speech. And I am aware of the lawsuits that manufacturers of the voting machines have been able to successfully bring to court, and I believe they're still in process. But I'm wondering if there isn't a wider application of the rules in regard to slander for all of these kinds of crazy things that these far out right-wing organizations are putting out.
Okay, may I answer that? Slander, libel is not protected speech. Supreme Court, the court has said that. Just obscenity is not protected speech. Slander, libel are not protected speech. The question is, what is slander and libel? These are statements that are untrue. Now, as far as a private citizen is concerned, a private citizen has a great deal of recourse by means of a lawsuit. Now, of course, a lawsuit creates dangers for people who might have questions in their background, because the accused will undoubtedly raise all sorts of things about the character of the individual and so on, which sometimes makes it difficult to do that. There are some very interesting historical examples of that. Supreme Court in 1964, what's called the Sullivan case, came up with a ruling, arrived at a ruling regarding slander and libel for public officials, which set an entirely different standard. You see, if I were to say you were dishonest, or you were to say I'm dishonest and so on about me and so on, I have proof, etc. I'll win. You look like a very wealthy person. I could probably take all of your money if I could prove that you said that about me. And even if you believed it sincerely, it wouldn't help. It's a lie. Supreme Court dealt with the problem, however, what happens if a newspaper were to make a statement about a public official, which it seriously sought to investigate, and it turned out to be wrong after all was said and done? Could a libel suit against that public official stand? And the court established a standard that is different for public officials. Unless there was what they call malice aforethought, you knew they was lying, and you'd never tried to determine whether it was true or not. Unless it were that case, and generally the press is protected. Now, the kind of things you're talking about, QAnon and so on, these statements are so farcical, they're so ridiculous, there's no protection except for the fact that that crazy lawyer in Georgia said, well, maybe you shouldn't take what you said seriously because who would believe it in any case?
Oh, yeah.
I mean, that's bizarre, but that's the kind of thing we're talking about right now. Generally, if you say somebody is a pedophile based upon the kind of evidence that these people have, you're going to lose. You have no protection for that. People's reputations have to remain intact. Let me give you a good example. If any of you are interested in a wonderful book with some real cases of libel, there's a lawyer named Louis Nizer, is spelling Nizer. He was a famous lawyer in the United States in the 50s and 60s, maybe even before that. He wrote a book called My Life in Court. My Life in Court by Louis Nizer. And I'm sure you can find it on Amazon. And in it, he has 5 or 6 instances of libel cases where people who felt they'd been libeled came to Nizer asking for relief. And I recall his statement to every one of them was, you need to be very careful before you sue, because you as a defendant will find that your life can be opened up before the court and before the public. So if you're interested in that subject, Jennifer and others, you might want to look for that book. I recommend to my students, I think they cleaned Amazon out when I did that. The book is so old. My wife wants me to get rid of my library, so she might be, if she finds it, you might write her and she'll send it to you.
On that note, I want to just take a moment and thank Judge Firestone not only for your wisdom, but for your really decades and decades of experience. Thank you for speaking with us. Thank you for giving us space to be together to have these conversations. Next week, we'll learn a little bit about the situation around for LGBTQ folks in Israel, and we thank Shelley Elisheva in advance for that subject and the discussion that will come from there. Thank you all for being here. Have a wonderful rest of your Wednesday, and I don't think it's too early to say Shabbat Shalom. So Shabbat Shalom in advance to all of you.
Sorry to talk so long, and I think the expression is we hit the road, correct?
Yeah.
Okay.
Shabbat Shalom, and thank you so much. It was wonderful.